Extortion versus blackmail. Extortion is a crime that falls under the broader category of grand larceny by extortion in New York. It involves using threats, coercion, or intimidation to compel someone to part with their property, services, or actions against their will. The repercussions for those found guilty of extortion can be life-altering, including hefty fines, incarceration, and a tarnished reputation. Extortion charges in New York are not to be taken lightly. The consequences of being accused of extortion can be severe and far-reaching, potentially altering the course of your life. Grand larceny by extortion and blackmail in New York. Larceny charges in New York refer to the unlawful taking of someone else's property with the intent to permanently deprive them of it. Larceny is a broad category of theft-related offenses and encompasses various types of theft, such as stealing personal belongings, shoplifting, or embezzlement. Legal definitions and distinctions. Codified under New York Penal Law sections 155.30, 6, and 155.40, 2. Grand larceny by extortion involves the use of threats, coercion, or intimidation to compel someone to give up their property or services. It's a form of theft where the perpetrator gains possession of property by exerting pressure on the victim, often involving threats of harm, property damage, or other adverse consequences. Key elements of larceny by extortion. Larceny by extortion is defined by specific key elements that must be present for the offense to occur. These elements include: 1. Unlawful taking. 2. Intent to deprive. 3. Use of threats or coercion. 4. Victim's fear. Extortion and blackmail in New York. Blackmail, when done to deprive someone of their property, falls under the category of grand larceny by extortion. This is an important distinction from coercion, which is done to induce someone to commit an act or prevent them from doing an act. Penalties for larceny by extortion. In New York, grand larceny by extortion is a serious criminal offense that is categorized into different degrees based on the value of the property or money stolen, as well as the circumstances of the extortion. Each degree carries distinct punishments. Here's an overview of the different degrees of grand larceny by extortion and their respective punishments. 4th degree grand larceny by extortion. 1. Value threshold. 2. Punishment. 3rd degree grand larceny by extortion. 1. Value threshold. 2. Punishment. 2nd degree grand larceny by extortion. 1. Value threshold. 2. Punishment. 1st degree grand larceny by extortion. 1. Value threshold. 2. Punishment. Extortion and blackmail. Key points. When examining extortion and blackmail in accordance with New York laws, it becomes evident that these two criminal activities share certain commonalities, primarily involving coercion, threats, and a shared motive. Intimidation and threats in extortion and blackmail. Both extortion and blackmail involve the use of intimidation and threats to compel another person to comply with the demands of the perpetrator. In New York, the law recognizes that the underlying principle in both crimes is the exertion of undue pressure on the victim to gain an advantage, typically involving property, money, or some form of personal benefit. Intent to gain, a shared motive. One of the core similarities between extortion and blackmail is the shared motive of personal gain. In both cases, the perpetrator seeks to obtain something of value from the victim. This can include money, property, services, or even actions that the victim may be compelled to perform. Building a strong defense. Mounting a robust defense is imperative when facing charges related to grand larceny by extortion, including the distinct offense of blackmail. Building a strong defense requires a combination of legal acumen, strategic planning, and careful consideration of the unique aspects of each case. The vital role of legal counsel. Securing legal counsel is the cornerstone of any defense against charges of extortion or blackmail in New York. Experienced grand larceny attorneys familiar with the nuances of the state's laws are essential allies in navigating the legal complexities. They can provide guidance, protect your rights, and craft a defense tailored to your specific circumstances. Defense strategies for extortion and blackmail. Defense strategies for extortion and blackmail cases often hinge on challenging the prosecution's evidence and establishing a credible counter-narrative. Some common defense strategies include: 1. Challenging the intimidation or threat, contesting the validity of the threats made by the alleged perpetrator, particularly if they can be proven to be implausible or baseless. 2. Questioning intent, demonstrating a lack of intent to commit the crime, emphasizing misunderstandings or miscommunications between parties. 3. Alibi or lack of involvement, establishing that the accused was not directly involved in the alleged criminal act or that they have an alibi proving their absence during the event. Gathering evidence and witness testimonies. Gathering evidence and securing witness testimonies can be pivotal in building a strong defense. This may involve: 1. Collecting information. 2. Witness statements. 3. Surveillance footage. Negotiating with prosecutors. In some cases, negotiation with prosecutors may be a viable option to reach a favorable outcome. Skilled defense attorneys can engage in discussions with prosecutors to explore plea deals or reduced charges, depending on the circumstances and strength of the defense. The importance of legal representation. Working with a skilled Manhattan Grand Larceny lawyer is critically important when facing charges related to grand larceny or any other serious criminal offense. Here are several key reasons why hiring an experienced attorney in Manhattan, specifically for grand larceny cases, is essential. Knowledge of New York laws. Understanding of local practices. Case assessment. Crafting a defense strategy. Protection of your rights.
Negotiation skills. Trial representation.
Mitigation of penalties.
Emotional support.
Working with an experienced Manhattan Grand Larceny attorney from Lebedin Kofman LLP. Hiring a skilled Manhattan Grand Larceny lawyer is crucial when facing charges related to grand larceny for several key reasons. Our team of experienced New York City grand larceny attorneys at Lebedin Kofman LLP possess in-depth knowledge of New York's criminal laws and are well versed in local legal practices, judges, and prosecutors. We can conduct a thorough evaluation of the details of your case, craft a tailored defense strategy, and protect your constitutional rights throughout the legal process. We can help explore your legal options and, when applicable, negotiate with prosecutors for the dismissal or reduction of the charges. We can also provide strong advocacy and aggressive representation if the case comes to trial. Contact Lebedin Kofman LLP at 646-663-4430 today and schedule a consultation to discuss your options with a top-rated Manhattan Grand Larceny attorney.